by Skoda. Only on BloombergQuint.
Hello and welcome to BloombergQuint. News just coming in. A two-judge Supreme Court bench has pronounced the verdict on all the petitions that had challenged the constitutional validity of the Insolvency and Bankruptcy Code. We don't have a detailed judgment from the Supreme Court as yet, but we do know that the court has upheld the constitutional validity of the Insolvency and Bankruptcy Code in its entirety, which means that some of the petitions, now the two main broad arguments against the constitutional validity of the IBC was under Article 14 and Article 19(1)(g) of the Constitution. The petitioners had said that the code does not make any intelligible differentiation between financial creditors and operational creditors, and to that effect it violates the Constitution. The second challenge was on Article 19, which said that because the code places the fate of the corporate debtor in the hands of a resolution professional who is not equipped to decide the fate or manage the company, is why and it prohibits the promoters to carry out trade as per Article 19, is why it violates the Constitution. The Supreme Court, as we understand, has dismissed both these arguments. My colleague ARPAN CHATURVEDI is on the phone line with us, who was there in the court. ARPAN, do we know anything else besides the fact that the Supreme Court has upheld the IBC?
Well, Paisani, so as far as the written judgment, whatever was pronounced in the court today is concerned, there's only one line that Justice Nariman pronounced in the court. He came and he said that the act has been upheld in its entirety, except for the part that when it comes to related persons in the mentioned in the court, that would mean people who are connected with the business. So that was the only two lines that he read in the court. Now, as far as the specific arguments and what stands and on what BC has those been rejected, that we'll of course get to know once we see the judgment that's been up, once it's uploaded on the Supreme Court website. But as far as the legal arguments are concerned, this case saw basically the act, large portions of the act challenge, which was whether it's for appointment of the members at the adjudicating authority, the composition of the adjudicating authority, which is your NCLT, NCLAT, or whether there was argument saying that there was the act sort of discriminates to the operational creditors. These were some of the arguments that were put forward, but the court has clearly rejected all the arguments and has today upheld the act in its entirety.
Okay, Arpan, could you take us through the background of this related person argument? Why did it come up in the court during the course of the constitutional validity?
So, as far as that is concerned, Paisani, so we saw the main challenge, also one of the main arguments was here, this was in the definition clauses, and that was what the petitioner, which was also, remember, former Attorney General Mukul Roy, who started the argument for the petitioner. So they had been contending that this is in violation of the constitutional provisions, and these are not legitimate distinction that has been made. And the top court, of course, today said that this was more of a clarification or a clearance that they have made in the definition. And apart from this, there hasn't been much relief that the petitioners have got. Remember, there was also a major part of the challenge, and the major focus in this was the ban on promoters bidding for the companies. That was also a part of the challenge, where they said that the promoters are not given adequate chance of hearing once the petition is admitted in the NCLT, because the NCLT has been given a short deadline to admit the case. So the petitioner said that our right of hearing is also violated. On those grounds also, the Insolvency and Bankruptcy Code was challenged. But again, the top court today has rejected and upheld the ban that was on promoters bidding for the companies as well.
Okay, if I might quick add as a background, there were several petitions filed in different high courts. Two of them which come to mind immediately are the Calcutta and the Gujarat High Court, and in the background of these petitions, the Supreme Court had specifically asked various high courts to not decide on the validity on whether or not the promoters can also bid, as part of the insolvency process. So looks like an important hurdle that has been crossed, in the implementation of the code itself. We will have experts joining in. We have Shardul Shroff of Shardul Amarchand Mangaldas joining us on the phone line. Mr. Shroff, thank you for joining us here on BloombergQuint. An important hurdle in the implementation of the IBC that we have crossed today with this judgment of the Supreme Court, sir?
Yes, definitely. Issues of constitutional validity are now finally sort of put a rest to. They should not arise again and again now.
Okay, all right. This one of when the Supreme Court had said that the IBC has been held in its entirety. We do know that there are several 12A petitions that are before the various high courts. I imagine those don't get impacted by this judgment, right?
No, as long as Section 12A is complied, there will be no issue. There has been one case where the Supreme Court, again under Article 141, has granted permission to sort of withdraw, and that has been done despite the fact that the procedure had already crossed the EOI. So there will be those cases where there may be sort of pending proceedings for allowing withdrawal even after the EOI, but that's a question which the NCLT and the NCLAT cannot approve. Only the Supreme Court can. That's the only caveat as I see. Since 12A is also sort of validated, if the applications in the high courts are consistent with the amended Section 12A, then there is no issue left.
Okay, we also have NILANG DESAI joining us from EZB. NILANG, as Mr. Shroff pointed out, the involvement of the promoters within the framework of the IBC has been struck down because if the code is upheld in its entirety, the contentious 29A has also been upheld. I think the next major challenge that is there on whether or not the promoters can, come back in some form is through 12A. How do you see that argument playing out, and is that what also will get resolved before the Supreme Court finally?
Yeah, well, so I think it's not all promoters. It's obviously only fluent promoters, number one. Number two, I don't think 12A really is, anything to do with 29A, because really what 12A says is that if you satisfy 90% of the lenders, then you can take your company back, and 90% of the lenders is a really high threshold. Well, 90% of lenders and the applicant. This is a really high threshold. So effectively what it's saying is if you resolve the issue, then you can come out of the IBC. Now, surely that's a pretty sensible way to proceed, and I don't think that's really in conflict with 29A at all.
What I meant to ask was that how can promoters come back in the game since the constitutional validity and 29A has been upheld? The other way that they can, come back in the control probably of their companies is through the 12A route, and that 12A, I'm guessing again will reach the doorstep of the Supreme Court to the challenge. And as Mr. Shroff also pointed out, we do have precedent where the 12A application was upheld in the Brilliant Alloys case. So now the question essentially is that it does leave the door open for the promoters as long as they can convince the majority of the creditors or the financial creditors that they should withdraw and do some sort of a settlement with the controlling shareholder.
No, that's right, and no, you're absolutely right. And I think that, again, as I said, that makes sense. In more cases than not, 12A is going to result in a high recovery for lenders. In many cases, it may even be the entire recovery. So if that is the case, then I see no problem with promoters coming back and taking the company. If they're repaying their debts, then what's the problem? 12A will reach the Supreme Court, I think, in the SHROFF judgment or SHROFF saga, if you like. But I don't know what the constitutional validity of 12A is going to be the question. Its applicability on the facts of SR is definitely going to be in question. Let's see how that turns out.
NILANG, hi, Vishwanath here joining in this conversation. Just wanted to point out this one clarification that the Supreme Court made about related parties and said that it has to be somebody connected to the business. Now, we know that within the related party and connected persons definition, the previous amendment included a whole host of family members. So you think that sort of distinction now goes away? Probably the family members may not be included then?
I think that's helpful. We'll have to wait and see how it plays out. In fact, the problem with writing a law like this is you're always going to have somewhat unintended consequences, in some cases positive, in some cases negative. does it make sense, for instance, if I have a brother who I've been estranged with for 25 years and has gone ahead and, defaulted on his businesses, for me to pay the penalty for that, it doesn't make any sense. But does it make sense, for me to be excluded from a bid where my brother is the defaulter and I'm merely doing something on his behalf? Yes. So, I don't know whether there are many ways in which you can include some and not all relatives on the basis I just mentioned, because that's such a factual inquiry. So I think the attempt made by Rohinton is a good one. We'll have to wait and see how it plays out in the actual facts of each case.
All right, we'll wait for the final copy of the judgment to be uploaded on the Supreme Court website to really see the implications on many of the issues we've discussed with Mr. Shroff and Nilang. Thank you both for joining us here on BloombergQuint, and thank you so much for watching.